Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, the founder and chair of ICANN, Investor Choice Advocates Network, and I am joined, as always, by the co-founder and co-host, Tom Zucchero. Tom, how are you doing?
I'm doing well, Nick. How are you?
I'm doing well, doing especially well because we're joined by our longtime friend and former SEC colleague, Peter Altman, who is now a partner at Akin Gump, former SEC enforcement attorney. Peter, thank you so much for joining us.
Thanks so much, Nick. Appreciate both of you having me on today.
A pleasure. It's good to see you. So we wanted to get you on to talk about a current topic of interest, and it's a current topic of interest in two different ways, which I think you and Tom will address, and that is the subject of SEC Rule 10b5-1. It has come up, and you guys will do a better job of explaining this than I will, but it's come up in two possible ways. One, there's been some recent enforcement activity, both by the SEC and the DOJ, and Peter, you'll talk about that. And then it also, this Rule 10b5-1 has come up as a potential candidate for applying the recent decision from the Supreme Court in Loper. And Tom, you'll talk about that. So, Peter, let's start with you. 10b5-1 plans in the news recently with a recent DOJ trial and a parallel SEC case. Can you tell us a little bit about the case?
Sure, and you're right, Nick. Just actually a couple weeks ago, the DOJ secured a conviction in a insider trading trial that was brought in Los Angeles against an executive who was indicted for insider trading for avoiding a whole bunch of losses ahead of a disclosure of some negative public news about his company. And he was also sued by the SEC. Now, normally that wouldn't really be all that unusual. The case was notable because the trades weren't made through the open market. They were made through 10b5-1 plans, which is the topic of our discussion today. And just a thumbnail on 10b5-1, it's a tool that company insiders, as you both know, have used for years to be able to trade securities based on essentially predetermined conditions. Normally, it would be like in between reporting cycles for the company and at times when the executive doesn't otherwise have MNPI. And I think what's interesting here is this question of when does the trading decision happen for 10b5-1 purposes? And when you adopt a 10b5-1 plan, you're essentially saying to a broker, go forth and transact upon some future event happening, as opposed to when I pick up the phone or chat message you to go ahead and trade. You're making your trading decision when you adopt the plan. These plans have come under scrutiny in recent years, and the SEC recently adopted some amendments to Rule 10b5-1, most notably for the purposes of setting up how quickly the plan can kind of go into effect once you adopt it. There's now cooling off periods where somebody adopts the plan, period of time has to go by before the trading activity can actually happen. Now, a quick summary of the case, actually a pretty straightforward fact pattern as alleged by government. You had a founder and chairman of a healthcare company based here in Southern California who was alleged to have essentially adopted two 10b5-1 plans at times when he actually had MNPI. This all happened in 2021. And the idea was he knew things that the market didn't know about the company, and it was essentially tied to the company's relationship with its then largest customer, which was Cigna, and that Cigna had expressed some dissatisfaction with the company and indicated that it was likely going to terminate the contract. I think that the key evidence here actually was around the adoption of the plans. What happened was what the government introduced evidence of was in May of 2021, the defendant goes out, calls up a broker and says, hey, I want to put on a 10b5-1 plan and I want to start trading pretty quickly. And the brokerage firm says, sorry, there's a 14-day cooling off period between when you adopt and when we can start executing for you. And he says, thank you very much, hangs up the phone. He calls another broker, and the other broker says, well, industry best practice is that there's a 30-day cooling off period. Now, mind you, all of this happened before the new amendments 10b5-1 took effect. But the second broker says, but we can put on the plan that you want. And sure enough, the plan gets adopted and trades start happening the next day. And again, remember, he's alleged and he was found guilty of adopting that plan while he had MNPI about his company. He does this again a few months later, and then, at least per the DOJ and SEC press releases, their data analytics pick up kind of the correlation between when the plan goes on, when he's when the broker's executing on his behalf, and when the MNPI is getting released to the market. So as I said, a pretty straightforward fact pattern, with the wrinkle being 10b5-1 being the tool by which the trades are getting executed.
Yeah, that's fascinating, particularly because 10b5-1, which is a rule the SEC promulgated, was intended to provide a safe harbor from insider trading exposure. And I think, as you just pointed out, Peter, it is the use of 10b5-1 here that was the basis for the criminal charges and the parallel charges. Well, one of the things you mentioned was that the defendant in that case had MNPI, which is material non-public information. And so one of the things that Rule 10b5-1 purported to do was to resolve a long-standing dispute in insider trading law, which is whether the SEC has to prove that the defendant merely possessed material non-public information or used material non-public information. And for more on that dispute and 10b5-1, Rule 10b5-1's role in that, and just to layer in the recent Supreme Court ruling in the Loper case, which said that courts no longer need to provide agencies with so-called Chevron deference. Professor Tom, how is it, like, you had a case that involved this very issue? So how is the Supreme Court's recent ruling likely to impact SEC enforcement around 10b5-1 insider trading issues?
Well, thank you, Nick. And Peter, thank you for that great summary. I think it's going to have a significant impact. Going back 25 years, there was a disagreement among the circuits as to what the SEC needed to prove to demonstrate that someone traded based on inside information. And the Ninth Circuit, for example, said the SEC actually had to show that the defendant used the information when making his trade or her trade. Other circuits were more lenient and said, so long as the person possessed or had knowledge of the insider information, that would be sufficient to show insider trading. So there was a difference among the circuits. And in 10b5-1, the rule that the SEC adopted, which I believe was in 2001, the SEC resolved the use versus possession debate and said it's enough for the SEC to show mere possession to prevail in an insider trading case. Now, the defendant would have an affirmative defense to say he didn't use the information in making the trade, but to prove its case, the SEC merely had to show possession. So I had an insider trading case about 10 years ago, and we argued to the judge that Ninth Circuit law should be applied, and the judge should instruct the jury based upon the higher standard, the use standard that the Ninth Circuit had adopted prior to Rule 10b5-1. The SEC argued that the court should apply Chevron and give deference to the SEC's rule, because the SEC is the experts in securities law. Their job is to enforce the securities laws. The SEC said, Judge, you want to give deference to the SEC rule, and therefore we're only required to show mere possession. The court agreed with the SEC, and based upon Chevron, gave deference to the SEC's rule and instructed the jury that mere possession was sufficient for the SEC to show that the defendant made a trade based upon material non-public information. Now, fortunately, the other evidence favored our client, and we ended up winning the case. But that was one issue that arose in the jury instructions. So today, if that same issue arose, a defendant would argue the Ninth Circuit law applies, and the court's not required or entitled or permitted even to give deference to the SEC's interpretation. I don't believe there's been a case yet where that argument has been made, but certainly if I had an insider trading case that I was defending, I'd certainly make that argument in terms of what the proper jury instructions should be.
Yeah, one case where it strikes me as it might come up is in the shadow insider trading case that's currently on appeal in the Ninth Circuit. I don't know whether Chevron deference came up there, but I suspect use versus possession might have. So interesting.
Yeah, excellent point.
Well, we'll send an email to the defense lawyers there and encourage them to use the recent Supreme Court decision. Well, I expect we'll be seeing more application of this idea in future cases, and maybe the three of us can get back together when we see the next judicial opinion come out on the point. So in the meantime, Peter, thank you for joining us. Tom, thank you, as always. And for everybody else, if you want more information on ICANN, it's icanlaw.org. Otherwise, we'll see you on the next SEC Roundup. Thanks.